A courtroom is not just a building, it's a pressure cooker, a place where one wrong move, one emotional break, or one violent reaction can turn routine legal procedure into unforgettable public record. The hearings you're about to hear were not designed to make headlines, yet they did, because the defendants involved didn't just test the boundaries of the courtroom, they shattered them. Today we're diving into 3 cases where courtroom behavior became the crime itself. This is the story of Sidney Newsome, Michael Thomas, and Eddie Villalobos. Real defendants, real judges, and real consequences. Sidney Newsome's case began in the courtroom, but it didn't stay there. Newsome was 41 years old at the time of the hearing in Kansas City, Missouri. What seemed like a simple paperwork handover turned into a violent scuffle that required immediate judicial intervention. The hearing centered around legal paperwork that had been signed and passed to the judge for verification. Newsome's mother and brother were in the audience, watching the process unfold, hoping for calm. But calm wasn't part of his plan. When the bailiff physically blocked Newsome's approach toward the bench, he became tense and resistant, reacting not with legal intention, but impulsive anger. In countless U.S. courtrooms, deputies are trained that the moment is not about force, it's about technique. The objective is to control the environment in the least violent way possible, especially when jury involvement or public safety is at stake. The defendant's agitation reached a point where the bailiff grabbed Newsome by his collar for control, but he reacted violently. This became a physical altercation, not just involving the defendant, but spilling into the family seating area, where panic spread instantly. His brother rushed in to hold Newsome down during the arrest, but law enforcement later released the brother after verifying that his involvement was not criminal, but emotional reaction. This moment stands as a reference in American courtroom cases for one important legal truth. Courtroom conduct can generate contempt charges independent of the original case. Sidney Newsome was not sentenced for murder, robbery, or assault during the hearing, but for contempt of court, a judicial mechanism activated when courtroom decorum is breached through misconduct or procedural disruption. The judge himself stepped in physically to restrain the defendant on the table when officers' containment failed momentarily. The defendant was then dragged out in cuffs, and once the environment was neutralized, the sentence was delivered: 48 hours in jail for contempt. Contempt sentencing, unlike violent felony sentencing, is corrective, short-term, and legally distinct. It exists not for emotional retaliation, but to protect the dignity and neutrality of the legal process. This case teaches us something powerful. Not all courtroom chaos comes from dark crime scenes. Sometimes the crime becomes the behavior in front of a judge.
Don't do that!
Now let's move to Milwaukee, Wisconsin. Michael Thomas's case stands in stark contrast, not because his courtroom behavior was louder, but because of the emotional impact radius surrounding him. Thomas was just 17 years old when his sentencing hearing took place in the Milwaukee County Courthouse. The charges came from a tragic attempted robbery that turned into reckless homicide, where the victim was a pregnant woman, fatally injured during the incident. Thomas's legal processing happened within juvenile jurisdiction, where rehabilitation and mental evaluation are always prioritized over maximum punishment meant for adults. But the moment that made his hearing explode internationally wasn't the robbery itself, it was his family. At the precise moment sentencing was delivered, Michael Thomas's family, sitting in the courtroom, erupted in rage and shock. They bolted toward the benches in emotional panic, not attacking the judge, not introducing criminal threats, but disrupting courtroom neutrality through emotional contagion. U.S. juvenile courts are particularly sensitive to emotional disruption because the objective is not punishment, but mitigation, psychological rehabilitation, and procedural fairness without jury or environment bias. No bail amount was doubled, no terroristic criminal threat was evaluated. The defendant was not charged with intimidation nor threats toward a public official during this hearing. What happened instead was containment. Thomas was overpowered quickly by courtroom deputies to restore order, following judge directives not to escalate emotionally toward defendants, but to neutralize crisis with bias-free procedure. Michael Thomas was sentenced to a long jail term due to the gravity of the reckless homicide proceedings, but no remorse or contempt enhancements were applied in the exact viral clip moment described in the transcript. Juvenile recklessly violent defendants face rehabilitation custody environments, such as youth detention centers or psych evaluation systems, not lifelong maximum prisons unless adult enhancement or heightened criminal intentional involvement is proven later at trial. Thomas may have had violent intent in his robbery attempt, but he did not threaten a judge that day like some adult defendants do. His family's explosion became more viral than his sentence, and that virality has taught viewers a deeper truth. Courtrooms have emotional limits, even if the defendant follows legal rules. Families don't always follow emotional ones. But judges are not there to rehearse emotion. They are there to rule on risk. And when risk comes from emotional disruption, the court proceeds through safety guidelines. Now we head to Hillsboro, Oregon, to a defendant whose viral fame wasn't earned by words or family reaction. It was earned by distance. Eddie Villalobos was a 26-year-old defendant when he appeared in court in Hillsboro, Oregon. His charges included reckless driving, unlawful use of a weapon, reckless endangerment, and murder. His crime had been a vicious, personal stabbing of an acquaintance at his apartment complex. He entered the courtroom restrained at the ankles and waist, not as humiliation, but standard safety protocol in violent felony hearings. To keep juries unbiased, judges sometimes order that restraints be temporarily removed during trial. A defendant restrained visually too harshly in front of a jury can influence perceived character more than evidence ever should. The court evaluated him. Deputies removed visible shackles, and that's when, while standing to stretch his legs, Villalobos bolted, not toward a judge, not toward a lawyer, toward freedom. Deputies chased instantly, but juries don't influence chase protocol. Officers do. He almost reached the bottom of the courthouse stairs before police closed the distance. But while charges like reckless endangerment and unlawful use of a weapon already pointed to risk, the escape attempt elevated his legal jeopardy infinitely. Not because it was destructive, but because violating temporary restraint removal in a murder environment signals flight risk severe enough to deny bond universally in American law. Even a few minutes of freedom is unsustainable for violent defendants. Later that night, residents in the same apartment complex noticed anomalies: a broken door, an open closet, fear spreading through bystander proximity. One worried resident called the police, which ultimately led investigators to find Eddie hiding in a closet inside a vacant house within that neighborhood. Eddie's escape lasted just a few hours, but the closet was where his freedom ended. He was pulled out and placed back into custody. This case teaches a legal and psychological principle both creators and viewers must understand. Escape attempts inside a violent felony trial environment are not treated as rebellion. They are treated as evidence of procedural breach and flight risk. And flight risk is one of the biggest bond denial conditions in America. No matter who you threaten, no matter how loud you argue, judges respond to danger differently, and the law responds to record. Roman spoke threats. O'Brien carried weapons. Rhodes unraveled under pressure. Newsom sparked a physical scuffle. Thomas spread emotional panic. And Villalobos ran downstairs for unsustainable freedom, eventually caught within neighborhood walls narrower than his alleged crime scene had ever been. These stories may begin like viral clips. They end like court records. Judges don't punish drama. They punish risk, breach, intent, or disruption. In the U.S., bail is not a right. It's a safety decision based on severity, flight risk, threats, or weapon presence. Contempt sentencing is corrective. Felony sentencing is expansive. Words are weapons. Weapons are intent. Intent is record, and record is forever. Every courtroom viral moment isn't remembered because it's loud. It's remembered because it was real, and the law took it seriously. And now those recordings serve as reminders that the courtroom isn't where you intimidate the system. It's where the system evaluates you. Because while defendants may get a moment to speak, or stand, or stretch their legs, they never get a moment to rewrite the truth once it enters the record.